Welcome to Office Hours. All right, today I'm going to continue going over some commercial lease documents. This week I'm going to focus on amendments and addenda. Next week I want to talk about subleases because that's its own very exciting thing. And also potentially a situation where people tend to get themselves into some trouble, subleases. So, well, if you try hard enough, you can get in trouble at any stage of the commercial leasing process. So that's fun. All right, so let me share my screen. Great. And there we are. I appear to be live. All right, so the Texas Realtors Commercial Lease Amendment. I want to cover this first because it's very just kind of open-ended. You can do a number of things with this. First thing you would do is identify the leased premises here in this blank, give an effective date. The leased premises change. Now the idea here is that we're checking boxes if what we're amending the lease to do concerns this. So, for example, if you're doing a lease premises change from one suite to another, or you are increasing or decreasing the size of the lease space, you would fill in with this blank here. Then the term. If we are changing the term of the lease, we would change it here. B1. B2 lets us change the commencement date. B3 lets us change the expiration date. One example could be if we've extended the term. We could say, if it was originally 60 months, but they want to do an additional 5 years, we could say the term is 120 months, right? Which there we could just extend the expiration date in that case. If we had a delayed commencement date due to some sort of construction issue, we could change the commencement date and the subsequent expiration date here while keeping the total term of the length of the lease the same. Rent, the amount of the monthly base rent. So if we are changing the rent for whatever reason, if you're downsizing the lease space, you're going to want to change the rent. If you're increasing the lease space, you're going to want to change the rent. If you're extending the lease term, you're going to want to know what the rent is for the term of the extension period. There's also a thing I've seen in leasing frequently, something called a blend and extend. So let's say you sign a lease for 5 years, and then 3 years in, you want to extend the lease, but also you've noticed that lease rates across the board are kind of lower now than when you signed your lease. What you could do is tell your landlord, hey, I want to extend the lease, just negotiate an extension now, but I want to do it at a lower rental rate than what I'm currently paying to take of current market rate. So that's what that would do. This could be kind of deal with the term of an earlier agreement, or this could deal specifically with the rental rate for an extension term. Either way. See here we have the ability to change the security deposit. If we want to change who the responsible party is for different maintenance and repairs, we can do that. If we want to change the parking terms, we can do that. And there's just a big blank here. Also, we can change other paragraphs to read a certain amount, right? So big open area. Again, if you're, I mentioned this before, if you're a license holder and you're not an attorney, don't write in any legal changes here yourself. Get an attorney to do that. You don't want to be accused of the unauthorized practice of law. That's as true in commercial real estate as it is in residential real estate. And then we have landlord and tenant signing here. All right, so this is very kind of open-ended, and the idea is it is a way for you to change a lot of different things at once. I would call this kind of a greatest hits document because you have all of these things that you can amend just in one document. Let's look at some more kind of focused documents next. One example would be the commercial lease addendum for broker's fee. This is basically just restating the agreement that was in place or should have been in place initially. Either you include this information in the lease agreement or you don't, and you cover this all in an addendum or a completely separate agreement, right? There's a lot of ways to do this. But here we have the fees for the initial term of the lease. We have fees for renewals or expansions. I will say this from a landlord perspective. Once they have put out the outlay for tenant finish, once they've put out the outlay for the brokerage fees for a new tenant, um, by and large, unless something changes, they are not going to frequently want to pay brokers fees to brokers if there's a renewal. If there's an expansion, maybe on the expansion space, right? But for renewals, they might be willing to pay something, but it's less, right? There's a certain amount of inertia in commercial real estate where you assume unless circumstances change quite a bit, that a tenant's existing space is probably going to keep serving them pretty well. So, just paying for a renewal, you might pay a lower amount, or you'd have some other arrangement, but it's not going to be as much as the initial term, just because there's less work going into it. Fees in the event of a sale. So this is if the tenant agrees to purchase the lease premises, comes up for sale. So it's not one I've really seen exercised a lot, that particular option, to buy the property, but every now and then you see it. All right, so that's a pretty simple one. Let's look at a couple of addenda that have to do with a tenant expanding their space. The first is a right of first refusal. It's also called a ROFR, R-O-F-R. This is a document that would essentially give a tenant first look or first option at certain additional space in the building. So we're assuming this is a multi-tenant building. The idea is a tenant may not want to expand right now, but they may want to reserve that right. So if there are, here we're defining additional space, right? So this can mean the following floors of the property. So you could say they have a right of first refusal for any other lease space that comes up on their floor. It could be some specific suites, maybe the suites that are directly adjacent to theirs, right? Or it could be something else. Maybe it's a building where you could potentially cut through a floor or ceiling and create a, put in a staircase and link some spaces that way. So they might want any space directly like above or below them. Again, assuming it's a multi-story space where you could potentially cut into a ceiling or floor. So however you define this additional space is what it's going to depend on. Right. So the idea here is this is the right of first refusal. If the landlord receives an acceptable written offer from another person to lease the additional space at a time when the above reference lease is in effect, landlord will notify tenant of the offer. Not later than 7 days after tenant receives landlord's notice of the offer, tenant may notify landlord that landlord will lease the additional space identified under the same terms and conditions of the offer. So essentially, hey, we've gotten a bona fide offer at what we consider to be a price that we would rent this to someone else for. You have 7 days to decide if you're willing to pay us this to lease the space. If tenant notifies landlord that they will lease the additional space, the tenant must execute a written lease for the additional space identified in the offer, or amend the above reference lease as landlord may require not later than blank days after tenant receives landlord's notice. So that blank is going to depend a lot on the tenant. It's going to depend a lot on the landlord as well. So let's look at it from the landlord's perspective for a moment. If you're a landlord and you've gotten an offer in on a space, you have this right of first refusal. What you don't want to do is have the party that has the right of first refusal, you don't want them to sit on an amendment or a lease for this space for so long. They'll say, yes, we want to lease it. And then they sit on it for 60 days and you don't have the ability to move on the other offer for another 60 days, right? If 60 is the number of days in this blank, right? Because at that point, whoever was interested in leasing the property they may have already found another option that would work for them. So we don't want that. So it needs to be a period of time that's not so long that it would scare off the original offerer, right? At the same time, you also have to consider the tenant and what it takes for them to get a lease signed. I will say that I have worked for clients who are tenants who getting them to sign anything in under 30 days was an absolute miracle, right? So, from that perspective, the landlord might say, I might say, oh, yeah, I'd love 90 days. That'd be great. And the landlord would say, no, way too long. We're thinking 15 days. And I might say, look, this is a big company that has a lot of moving parts. It's hard to get anything signed in less than 30 days. So that would be a stretch, but I think we could put that in, right? So the landlord might find that to be agreeable at that point. So if the tenant fails to timely comply with this paragraph, which includes the notification provision, the acceptance provision, and actually signing the agreement, then landlord may lease the additional space identified in the offer to the person who made the offer. If tenant does not exercise its right to lease the additional space identified in the offer, and landlord does not lease the additional space identified in the offer to the person who made the offer, so this is a situation where the landlord says, "Hey, we got an offer." Tenant says, "We're not interested," and then the deal falls through with the party that made the offer. So this is a box to be filled in. Does tenant continue to retain the right of first refusal for that space, even though they didn't want it this time? On the tenant side, I would want to say yes, they do. On the landlord side, I want to say no. If they didn't want it then, they're probably never going to want it, right? So that's a couple different ways of looking at that. An offer for part of the additional space affects the party's rights and obligations only to the part of the additional space identified in the offer. Rights and obligations of to parts of the additional space not identified in the offer are not affected. An offer to renew a lease for the additional space from a tenant occupying the additional space is not an offer to lease the additional space for the purposes of this addendum. So if there's already a tenant in some of that additional space, or then and they renew, that doesn't trigger this right of first refusal. It has to be for a new lease. You have a special provisions area, big blank you can fill in if you need to. And then we have signatures of everyone. So that's a right of first refusal. We also have an addendum for tenant's option for additional space. This is another way for a tenant to expand its space. Again, traditionally, this is going to be space that's already vacant. But the idea here is tenant's ability to expand does not hinge on another party wanting to lease it. It is just the tenant deciding whether they can do this. So we're going to define the additional space, right? We got a lot of room here to do that. The parties agree that the rentable area of the additional space may not equal the actual or usable area within the additional space and may include an allocation of common areas in the property. We're just covering our tracks as far as how square footage is calculated. Tenant may, by providing landlord 30 days written notice before blank, so this is going to be a date certain. So this is one of the situations where you want to fill in an actual date, right? Add the additional space to the lease premises defined in the lease. Any addition of the additional space to the lease premises is effective on the first day of the month following the 30th day after the tenant provides notice. So the idea here is this is a time-limited ability to add to the space, because the landlord doesn't want to just sit on it and never try to lease it out, because this tenant might decide to expand. So this is probably a situation where a tenant wants to execute an initial lease, and then once they've done that, they part of that they weren't sure if they want additional space or not. They would get this addendum for additional space, but they would have to decide within a certain fixed period of time whether or not they're going to want that space. And then we have the details how this works. If they add the space to the lease premises, the monthly base rent is going to be amended to dollar amount, the larger amount based on the new square footage. Tenant's pro rata share will be amended to blank. They're occupying a larger percentage of the property. And we have some other blanks here as well that you can fill in, right? Then, unless otherwise agreed in writing by the parties, tenant will accept the additional space in its present condition. Landlord is not obligated to complete any improvements to the additional space. That is because we're already saying this is going to be 30 days after the date tenant provides notice that they will take occupancy of the premises. Great. And then if landlord receives an acceptable written offer from another person to lease the additional space before the time specified in paragraph B, before that drop dead date, landlord will notify tenant of the offer. Within 7 days after tenant receives the offer, tenant may add the additional space to their leased premises. If tenant fails to add the additional space, landlord may lease the additional space to the person who made the offer. If tenant does not exercise the right to add the additional space and the landlord does not lease the space, tenant does or does not, you have to check that, retain the right to lease the additional space. So it becomes, they've embedded a right of first refusal inside of this expansion option. So that's interesting to know, but that's, depending on how far out that date is, right? That could be a concern. And also, this gives the landlord an incentive to continue to fill the vacant space in their building, not just have it tied up by a tenant with an option on it. We have a big space for special provisions if any needs to be added in, and then we have the signature blanks. Awesome. Very common lease addendum would simply be a term extension. Someone leases a space for an initial 3 years. They want to lease it for another 3 years. They don't want to really change anything else. Great. So as opposed to filling out that earlier lease addendum that we went over that has all of these different things that you can fill out, this is a little more focused. It allows us just to extend the term. This talks about when tenant can exercise their option to extend the paragraph, to extend under paragraph A. They have to provide written notice to the landlord at least X many days before the end of the current term of the lease. And that's good. This is the sort of thing where, as a landlord or a leasing agent, you would be keeping an eye on that time frame, because if the tenant had to provide notice to the landlord at least 180 days before the end of the current term, you're going to have a little ticker file, and when it's 180 days and then -1, right, you are going to then, if you have not gotten notice that the tenant wants to extend the term, exercise their option to extend the term, you're then going to start marketing it to other potential tenants with the idea that this tenant is likely going to be vacating because they've not exercised their option to extend the term. They can't exercise their option to extend the term if the lease is terminated before they exercise their option, or they're in breach of the lease at the time they exercise their option to extend. This is one reason why it is, if you're a landlord, it's very important to really keep tabs on your tenants and notify them if they are in breach of any part of their lease, right? Remember when we went over the lease, it's a long document. There's a lot of potential things a tenant could be in breach about. So you have to notify them when that happens, and then you allow them a period to cure per the terms of the lease. But yeah, I've seen landlords get very aggressive with documenting breaches in order to negate an extension option like this. So I mean, that is a tactic you can use, but you just have to. Ideally, you would only be doing that if you knew you had someone else you wanted to come in, and you just need to get rid of this tenant, regardless of their ability to exercise this option. This would negate the option. This states that during the additional terms, all provisions of the lease will continue except the base monthly rent. This gives us an opportunity to update that base monthly rent. Or we can just say the base monthly rent in the prior term is going to be increased using a consumer price index. Very common for setting out annual rent increases in long-term leases. Right? Also have this notion of the prevailing rental rate on the 45th day before the additional term commences for premise of comparable size, quality, condition improvements, utility, location, and length of term for tenants of similar credit standing as tenants. And this just bumped me. There should not be an apostrophe there, Texas Realtors. They updated this in 2022. I wonder if they've gotten a feedback on that. Maybe I should give them feedback. Yeah, so I will say that sort of calculation where you say, oh yeah, what the prevailing rental rate is 45 days before the term commences, that is a tricky one. And we can see that it's tricky because there's going to be more language about this just now in paragraph E. But I'm going to say that it is frequent that the landlord would say, "Oh yeah, well this is the prevailing rental rate," and the tenant would say, "Not in my universe. Where are you getting that number from?" So right here we have a dispute resolution paragraph. So paragraph D3 applies, right? And the parties do not agree on the amount of the prevailing rental rate for the additional term before the 30th day before additional term commences. So we have kind of 15 days to try and reach agreement there. Then each party will employ a state certified appraiser and deliver the appraiser's written opinion of the prevailing rental rate to the other party no later than the 15th day before the additional term commences. Now, I don't know how many of you have tried to hire an appraiser lately, especially in relation to commercial lease space. This is assuming you can get one, you can contact someone, get them hired, and get their report within 15 days, which I think might be aggressive. Any appraisers out there disagree? I'd be happy to hear from you. If the appraiser's opinions do not vary by more than 10%, the prevailing rental rate will be the average of the two opinions. If the appraiser's opinions vary by more than 10%, the appraisers will jointly select a third appraiser whose fees will be shared equally by the parties. If a third appraiser is engaged, the prevailing rental rate will be the average of the two opinions that are closest in amount. If either party fails to employ or timely deliver an appraiser's opinion as required by this paragraph, the opinion rendered by the appraiser employed by the other party will determine the prevailing rental rate. So you can't just short circuit the process by just not hiring an appraiser or not getting the opinion delivered in a timely manner. So this is definitely one way of doing it. This at least assumes a way of getting this resolved that is outside of the courts, which is always nice. I've seen other versions of this where essentially you submit the matter to arbitration, and I've seen different ways of doing that even. One way is the parties make their case to the arbitrator decides what the rental rate will be, which could be any number, right? But it could be between the numbers on either side, whatever it is. I've also seen provisions calling for baseball style arbitration, where the arbitrator can only pick one of the numbers selected by one of the parties. They can't make up a number of their own, which is also an interesting way of doing that. So a lot of different ways of doing that, but this particular option has this way in, and I don't see a huge problem with it, other than simply the issue of the timeline. And was this written when it was a little easier to get an appraiser out to do this? Yeah, if you're dealing with a timeline like this, what are you going to have to pay that appraiser, I wonder? Then we have obviously a big blank space for special provisions, if any. If none, I would just put NA. Then everyone signs down here. Great. I want to go over the parking addendum real quick before I go over the rules and regulations. Commercial lease addendum for parking. So essentially, this talks about 3 different types of parking. Well, 4 really. And you can have one or more of these, right? Common parking, essentially, if this is a building, just a common parking area that anyone in the building has access to, you say, yep, you're allowed to have X many vehicles park in the common area. And as the landlord, what you're going to be doing is keeping track of how many spaces you have promised out of how many spaces you have available, right? And it's also going to depend on your tenant mix. If you have tenants where there's, they tend to get a lot of visitors in, you're going to want to reserve space for visitors. Essentially, the idea of, oh, we have X many visitors coming to this building every day, so we tend to need X many parking spaces. If you have the types of tenants that don't tend to have visitors, then you can be a little more aggressive in your parking allocations. If you have tenants where there's kind of split work days, where the average the average employee there works from the office 3 days a week, that will also impact how you do your parking calculations. Parking assignment it's very much its own discipline. It's kind of fun to see. So you say we have a common area for parking. You could say we have parking in an area that's restricted for the use of tenants and employees of tenants. If you did that, then what you are talking about is the need to issue parking passes to people. And, whether that's a sticker or a hang tag or whatever, that's something else to keep track of, right? If you're a property owner or a property manager. We could also have some assigned parkings. You could have an office where there's 15 people, but as part of the lease, the president and the vice president each want an assigned parking space. So they'll, that could have their names, or the whatever, or the tenant name, however you want to do it, spray painted onto the parking space. But yeah, that would identify them as this is a reserved space. And then short-term customer parking. So if, like a bank, for example, a bank in an otherwise multi-tenant building, you have a bank on the first floor, you're definitely going to have some dedicated short-term parking for their customers. They can park, get in easily to the bank, and then get out. And you're going to just assume that parking for a bank is going to be pretty short-term. And I've also seen situations like that where it says, hey, short-term parking for the bank. If you're going to be more than 15 minutes, park in the common area, the common parking spaces. Don't park in one of the up close spots reserved for the bank, because that's only for short term. If you have some spaces that you're going to charge a tenant for, so that most commonly that would be for assigned parking, or maybe, again, in the bank example, the bank says, yeah, we want to have 4 parking spaces out front for short-term customer parking. Well, cool. But you're eating up some prime real estate on my parking operation, so I'm going to have to charge you for those as well, right? Definitely something you can do. I like this. Tenant may not assign, sublet, or trade any parking space or parking area. Yeah, they don't want people swapping that out. The landlord wants to know who the parking is assigned to, because they're going to want, it's a finite resource. They want to keep track of it. Similarly, tenant may not use any parking spaces to store any vehicle, boats, trailers, motorhomes, storage containers, or any other personal property. This is typically just going to be an insurance issue for the landlord. Their insurance carrier wants to know what is being parked in your parking lot. Cars, the cars that people drive in to work in the building, and that's it. Let's see, and tenants, guests, patrons, or invitees may park only in those areas designated by landlord for tenants, guests, patrons, or invitees. So if there's a separate, say, badged area for tenant parking versus a different area for guest parking, you have to abide by that. Speaking of which, landlord may, but is not obligated to, institute controlled access systems to the parking areas, including but not limited to systems such as vehicle identification stickers, license numbers, or controlled access devices. At the time the lease ends, tenant must return all access devices to landlord and pay the amounts in number 2 and 3 below if tenant fails to return an access device. So if landlord issues controlled access devices to tenant, tenant will promptly report any lost device to landlord, reimburse landlord its cost to replace the lost device, and lowered a service fee of X many dollars to be filled in for each lost access device. So when I've worked at buildings with parking garages, again, those are frequently access controlled. So yeah, this lets this lets the landlord know who's in the building, and this also lets the tenant do the dividing up of their spaces. Right, the tenant knows they get X many garage spaces, for example. They divide those up among their employees. But yeah, again, very common situation. If the employee loses their access badge to get into the garage, or their clicker, or whatever they use, they have to report that. That has to be, that particular access device is going to have to be disabled, removed from the system, and then a new one enabled and added to the system, and physically replaced. That's going to involve some costs. So this states, if the tenant fails to timely pay the rent as stated in paragraph B, which is the parking rent, landlord may exercise landlord's remedies under the default provisions of the lease, because they are violating a lease provision, right? So not paying your parking rent is as a lease violation, just like not paying your regular rent. They can terminate tenants' access to the restricted or assigned parking areas by providing tenant with not less than 5 days written notice of landlord's intent to terminate tenants' access. Yeah, you could say, hey, you're paying your regular rent, so I'm going to let you in the building, but you're not paying your parking rent, so I'm going to turn off your cards in 5 days. And if landlord terminates tenants' access to the parking areas under this paragraph, the parking areas will be deemed to be released by tenant for all purposes, and landlord may assign or lease the parking areas to others. Again, if they say, if we terminate your right to use these spaces, they go back into our pool and we can assign them to other tenants. As with these other documents, we have a big blank area for special provisions and then the signature blocks. All right, the last thing I want to talk about are commercial landlords' rules and regulations. So any commercial landlord wants to have rules and regulations about the conduct of their tenant in the building. I have seen rules and regulations manuals that are inches thick. So this is a very stripped down version of that. This is only 2 pages, but you want to have some sort of rules and regulations. So if you don't have one already and you're a landlord or a property manager, this is something at least, right? Or you can use this as the jumping off point to create something else. All right, and also worth noting, this is something you always say in rules and regulations. From time to time, landlord at its discretion may amend these rules and regulations for the purposes for which they are adopted. Under the above referenced lease, tenant agrees to comply with these rules and regulations as they may be amended. Exceptions or waivers must be authorized by landlord in writing. All right, so these are lettered. So first rule and regulation, goods, merchandise, equipment, or any personal property may not be stored on the property except for inventory within the lease premises necessary for tenants' normal business operations. Essentially, if you're a landlord, you want leased premises to be used for the purposes for which it's leased, right? So if someone leases an office space from you, you want it used for an office space. What you don't want to do is go in and find that they are now storing computer equipment because they've decided to become a computer retailer, right? So yeah, you don't want them operating a retail business out of the space if you lease it to them for office space, and you don't want them storing inventory there either. Food is not permitted on the property except as inventory for sale and for a small amount of food for tenants' personal consumption. This is going to be largely a pest control issue because you don't want people just storing big amounts of food that are going to potentially draw in pests. Other than those provided by a landlord or specifically authorized by a landlord, no vending machines are permitted on the property. Landlords will frequently, and especially in a multi-tenant building, not uncommon to have a vending machine in like the elevator lobby or the service elevator lobby or somewhere, right? Or somewhere in a tenant common area, you'll have some vending machines. And the landlord makes money off of that. So generally, if a tenant wants to have their own vending machine in their space, they need to get the landlord's approval for that. The property may not be used for lodging or sleeping quarters in any manner. Very common. Again, this is for commercial space, not for residential space. And again, for the landlord, it's going to be an insurance issue. Unless authorized by law or the lease, no animals may be brought or kept on the property. Yeah, this is going to be an insurance issue. This is also going to be like a cleanliness issue, right, for the landlord. But as authorized by law. So if a tenant has an employee that has a service dog or a service miniature horse, right? Then yeah, they can bring that on there. That's authorized by law. But I mean, there's companies I know that they'll have like, oh, take your dogs to work day. I've seen that at Amazon corporate buildings before, that it's perpetual bring your dog to work day. Lots of dogs. But yeah, the sort of thing where you are going to have that's either going to have to be approved by the lease or in this case, yeah, that's going to be your only option really because it's not normally authorized by law. It's just people's pets. So authorized by the lease. So if you were Amazon, for example, and you were going to, you knew that one of your corporate policies was we allow our employees to bring their, well-behaved dogs to work. That's the sort of thing you're going to want to put in the special provisions of the lease. So tenants are allowed to bring their dogs in. Now you wouldn't want them to board their dogs there overnight, right? They'd have to leave with the employee, but you would, if that was one of your corporate goals, you would want to have that in the lease then. No obstruction or interference that impedes use of the common areas, walks, drives, loading areas, parking areas, corridors, hallways, vestibules, or stairs is permitted on the property. Essentially, you want the property looking nice, not cluttered, and you also don't want any like fire egresses to be to be blocked by a tenant. So those have to stay clear per fire code and building code. So yeah, you want to make sure everything is kept clear for its proper and intended use. Persons parking on the property must comply with all posted signs and directions. Sure. No flammable, toxic, noxious, or hazardous materials may be kept on the property, except for over-the-counter cleaning materials kept in enclosed storage closets or cabinets. Again, this is the landlord wanting to keep their insurance premiums down, so they don't want you just keeping large amounts of flammable, toxic, noxious, or hazardous materials on the property. Tenants moving in or out of the property must use only the service entrances and service elevators during the move. All moves must be made at times that do not cause inconvenience for the normal use of the property. Yes, what you don't want is tenants moving in and using the regular elevators, because those tend to have a nicer finish out, and you don't want like the dollies or carts or whatever banging into the walls in there and creating dents or cracks or whatever. So you want them to use the service elevator, which is usually finished out in metal and is able to tolerate some dings and bumps, right? So that's very common. Deliveries and shipping of goods and merchandise in or out of the property must be made only through the service entrance, service elevators, loading docks, or other designated shipping and receiving areas. Shipments and deliveries must be made at times that do not cause inconvenience to tenants or patrons on the property. Again, incredibly common here. Leased premises must be kept clean and free of debris. Trash must be deposited into appropriate receptacles. Trash receptacles controlled by tenants must not be allowed to overflow, attract rodents or vermin, or emit odors. Landlord wants their space to remain nice. They don't want overflowing trash in the space. They don't want to attract vermin or rodents, right? I wonder what vermin they're thinking of besides rodents. Probably not koalas. Let's see. Repair requests must be submitted to landlord in writing in compliance with the lease. It's very common. A lot of landlords will just have an electronic system for you to submit repair requests. Standard. No modification to the property and lease premises may be made unless authorized by landlord in writing or permitted by the lease. Yes, the landlords typically do not want tenants mucking around with the layout of the property or, any aspect of the physical part of it, right? So you need landlord's written permission to do that. No illegal or offensive activity is permitted on the property, or any activity that constitutes a nuisance or interferes with the rights of other tenants. Makes sense. And then, unless specifically authorized by landlord, no solicitation or business operations are permitted in the common areas. Yeah, so what they don't want is you have an insurance agent that moves into the building. They don't want that insurance agent going around to all the other tenants and soliciting business. No. And they don't want them to set up a booth in the common area either to solicit people coming in or out of the building. They don't want that either. So they want it to be kept nice, let's say. And then we have a spot for other. So this could be several things. And this is going to be just depending on the building and its uses and any experience that the landlord has with these kinds of rules and regulations. They might say, yeah, these are generally good, but we have one or two other things. Cool, let's type them in here. There is no spot here for signature because this is not an agreement. This is simply the rules and regulations of the landlord. So you would get the parties to initial, right? Landlord and tenant, just initial to show that they received it. Other than that, it's not an agreement in and of itself, so you don't have to have them sign it per se. All right, so that is it for the addenda I wanted to cover. As I mentioned, next week I want to go over subleasing, and I may also next week touch on searching for commercial space in RPR. Maybe, we'll see. We'll see how subleasing goes. But yes, if you have questions about different commercial lease addenda or from prior commercial lease videos, if you have questions about that, happy to answer those. If there's an addenda I didn't cover, there are a few I didn't cover. I didn't cover the addenda related to build out of the space. That was just never like something I was particularly involved in. But if you have questions about that, I can always pull them up and talk about them. But yes, other than that, I will send out the notice for the next week's discussion, and I will see you then.